Alex here with part 90 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. And one more thing I wanted to mention for those of you who are wondering why you aren't getting all of the updates on the My Docket series. You have probably subscribed to the channel, but you haven't clicked on the bell notifications button. If you click on the bell notifications button, YouTube will take that as a signal from you that you don't just want to get the channel highlights, that you want to get each and every single thing that's been published to the channel. So this video goes into my ex's opposition to my motion to modify child custody. It is a pretty lengthy opposition, and I imagine most of my mindset will come out as I read through it. I haven't read through it. All I know is it's lengthy. There's a lot of pages. I do remember my mindset being extremely frustrated at getting this opposition because I felt like if my ex put this much effort into just trying to co-parent, none of this would have been required. And it was that much effort that she put into not trying to co-parent. I guess they call it counter-parenting. This is a new term I'm starting to hear, where a parent does everything in their power to get in the way, delay, set things back. They're not moving towards progress, or they're not moving forward in the relationship for the family. Even though they're separated, they're trying to sabotage the family unit. Anyway, a tremendous amount of effort goes into this opposition, and it's just really dismaying because the run up to that point in time, there were so many opportunities for all of this stuff to get hashed out, and it just didn't happen. At the same time, as I have stated in a number of my videos with regards to high conflict child custody, it didn't happen because she didn't want it to happen. That's one of the things I didn't get then that I get now. It's not that she just was ignorant or that she just didn't know what was going on. What happened in the case largely happened because that's what she wanted to happen. She wasn't just aimlessly wandering. She wasn't passive. She was very deliberate about the actions that she was taking, and the case ended up going in the direction that she wanted it to go. The funny thing about that is she never really was very good at planning something out long term. So I'm not trying to say that she thought to herself, I want to get this case to a TPR. It was like, next month I want to make sure he's been kicked out of school and he hasn't gotten his surgery. It was like she would think in terms of days or weeks or maybe the next month, and all of these things over the course of years led her to the termination of her parental rights. I don't think she had the ability to see that that was something that was coming, but she did very much plan and take actions in those shorter sort of time frames to satisfy whatever emotional needs she needed satisfied, typically vindication or revenge. I think at this point it's important, or pretty much what we're just going to have to do. At this point, we're just going to have to go ahead and take a look at what my ex's attorney has filed. Here we have my ex's attorney's opposition to my motion to modify child custody. She leads off with their standard introductory paragraph, identifying her client, herself as my ex's attorney, and indicating that she's filing an opposition to my motion to modify custody. Points and authorities, she leads off with a factual background. Pretty verbose, but we can go through this. First paragraph looks like a summary paragraph. Both myself and my ex share physical and legal custody jointly of our son, let's see here, was awarded to me and to, okay, that's correct. On July 21st, a hearing was held to modify the timeshare and determine the school. The court determined that our son would attend Coral Academy and modified the timeshare. A review hearing was ordered to be set May of 2012. Neither a review hearing has been set nor a modified agreement completed. We were ordered to attend co-parenting classes. She attempted to attend the class, but they were no longer offered, which is something that I already did say. On August 9th, 2011, our son started to attend Coral Academy. During the first exchange, I'm alleging that she kept his school uniform. She thought that I had bought 2 uniforms and that I gave her one for her half of the week. Okay, so if she thought this, then why wouldn't she have paid? I guess she's trying to say that I gifted it to her. She thought that. No, she lied to her own attorney. That's what happened, and her attorney just put it into the opposition without really verifying it. Which they don't really verify their own client statements. That's not their job. Their job is to win. So my ex isn't going to tell her, yeah, I kept the uniform and said get another one. What are you going to do about it? She's going to say, oh no, I thought he bought 2 and gave me one as a gift. Okay, it didn't happen, but okay. Next we have, according to my motion, on September 9th, we convened before the teacher and the dean, and the discussion did not focus on blame. However, due to my ex's refusal to sign an agreement, declarations were produced, which is good. According to my ex, she and I had several parent-teacher meetings. After doing everything that my ex could, he wasn't doing well. The school is not set up for struggling students. See, that's her play. She's trying to make it seem like he is a bad child and he's not going to fit into the school. She doesn't really care that any of that's not true. She just doesn't want him going to that school because that's the school that I chose. It's that simple. So it's basically her way of fighting the court's order, is trying to sort of engineer his failure. Don't worry, guys, it doesn't happen. He is now in 8th grade and he is still at Coral Academy of Science. He's doing great, gets A's and B's. This is just what she was trying to do when she had the power to do this. Next paragraph, my ex acknowledges that I tried to force her to sign. I never tried to force her to sign anything. The school did. She refused. What? No agreement has ever been received? Of course not, because that story's concocted. So the attorney is saying that she never received an agreement from me because I never sent her one, because it was never requested of her, because I never asked her to sign it. It was the school. There is no language stating that my ex is ordered to sign written agreement, blah, blah, blah. This is a waste of our time. This doesn't go anywhere. Moving on. Let's see. My ex states that she states that I should consider putting our son in another school since he isn't going to Coral Academy, and that he might benefit from kindergarten twice, and that maybe another school would help more. I threatened my ex saying, if you try and take him to another school, I'll file in court, which is exactly what I said, because it's exactly what she's not supposed to do. You know what's crazy is that my ex is portraying this as a discussion where the teacher and the dean were like, he's not going to fit in here, he's got to go. But that's not at all what happened. The teacher and the dean said, he's a really bright child, we think he's going to do great, we just need him to come back next year. So she's trying to recharacterize how this all went down. And she's trying to say that nobody wants him there, not even the school, and that I'm the one that's stubborn and I'm trying to force him to go to the school. When in actuality, well, you've all read the declaration. The teacher has stated that according to the standards of any school, his behavioral issues are a problem. It's not just Coral Academy standards. Punching a kid in the face, stuff like that is a problem at any school, not just that school. And then, of course, the remainder of the kindergarten teacher's declaration goes into my ex's conduct. This kind of stuff is so infuriating because she basically just invents her own story. And the thing that's even more frustrating is it's not like any of you haven't seen this before. You're all on this channel for a reason. And it's like, this kind of response is kind of par for the course. It's kind of standard. It's kind of to be expected. And these kinds of actions that my ex was taking are what led me to videos like anticipating the response, which helps you figure out what kind of shenanigans they're going to pull to get out of their nonsense, and failing to agree, which helps you get out of the mode of I need to convince this person to do something, and get you into the mode of I need to convince the court to force them to do something. And then of course we have the video, I used to think it was called force, but it's called control, which explains that there are positive uses for control. So good videos came out of my ex pulling this kind of stuff. And I just remember that at the time that I was going through this, I was just completely caught off guard, because I didn't think normal people, and I guess it's not normal people that do this kind of stuff. I mean, I guess I thought she was normal back then. I didn't think people would do stuff like this. I didn't think people would go through all these motions and take all these actions and discuss things, and then when the time was right, characterize it in a completely different way. I just couldn't get my head around that. Like, how can you do all of that and then go to your attorney and tell them completely different things have occurred? Now, that was when I was a naive individual. I'm no longer that naive. I realize that this is something that happens more than in just a courtroom. But anyway, let's continue. On August 22nd, our son returned to kindergarten at Coral Academy. On the first day of class, she showed up to pick him up. As she waited, all the kids came out except him. The teacher didn't say anything to her until she came up to her and asked, "Where is he?" And the teacher responded, "He's in the principal's office." She went straight to the office upset because no one called her, and school officials claimed to not have her telephone number, even though she'd given it to him twice. She gave it to them again and asked if they could have the teacher call her, since she didn't want to talk to the teacher in front of our son. The teacher never called, never wrote a letter, never wrote an email. The discipline coordinator was the one that told her what happened. So what's happening here is my ex is trying, and this isn't just a school thing. I know I have a lot of viewers who have seen this happen to optometrists, dentists, medical providers of other sorts, where their high conflict ex will just be a huge jerk to all of these providers. And what they're trying to do is trigger rejection. They want to cause these providers to reject them. And then they can use that to say, hey, you know that dentist you wanted us to go to, or that doctor, they just kicked me out. They said our son couldn't come back, and so we need to go to a different one now, and I'll choose this one. It's that kind of stuff. And she's trying to be as obnoxious as possible to all of these school personnel to try and get them to say, you know what, we're not going to deal with you anymore. You should just leave, which would then cause her to email me and say, hey, the school doesn't want our son there. That's what she was trying to do. Luckily, it never happened. Or my ex admits that he missed a total of 7 days of school while he was under her care. The missed days were due to a family trip, him being sick, and one time when she was sick and unable to get anyone to take him to school. During those times, she was unaware of the school policy. This is a lie. I have a number of emails that I sent her. So you know what's good about this, guys, is I'm actually kind of forcing her to lie. And if I had an attorney, maybe they would have leveraged this. I'm not sure. Maybe not. And if I had the experience that I have now back then, I would have definitely leveraged this. But you can, certain things that she's done have put her into a corner where she's forced to either admit something terrible or to lie. And a statement like this I could easily disprove in court, and a good judge would do something with that. The judge that I had probably would not have done anything. So maybe even though I didn't really know what I was doing back then, it doesn't matter, because even if I had known, the judge might have just said, okay, well, she said she didn't know about the rules, she lied, she did know the rules, and she didn't take him to school, but who cares, she should still have custody. That's probably what he would have still said. He would have used a more fanciful phrase or something like that, some kind of canned answer. But the judge that I happened to have at the time was the type that probably wouldn't have done anything to her unless she like punched him in the face or stabbed him or something, which is unfortunate, but that's just the type of judge that I had at the time. The second judge that I had might have taken action, but I'm hesitant to say that she would have modified custody, but it's much more likely that she would have. Sometimes it comes down to the judge, and that's unfortunate because it really shouldn't. It should come down to the law and what's in the best interest of the child, but because of the way that most of these family judges are able to exercise discretion, you end up with these sort of wildly varying situations. Anyway, I'm going to go ahead and move on. I allege that my ex has failed to send him to school with a backpack and water bottle. She didn't allow him to go to school with his backpack due to an incident which occurred last year, which got him into trouble. He doesn't carry anything in it, and he doesn't need it in kindergarten. She always provides him with okay, so apparently she's trying to say that on purpose she doesn't give him. Oh, I know what's going on here. Okay, so she would do this. This is something that she would do. It's very childish. She would, if she was confronted about something that she did that was wrong, there were a myriad of control mechanisms available to her to deflect or to blame the other person or whatever. One of those things is that she would say, okay, fine, since this is a problem, I'm going to do something worse. So she would do this quite often. I can already imagine the school would say, hey, he wasn't I don't know, he hit somebody with a water bottle or he squirted it at something or somebody or something like that. And so then her reaction, which is childish, would be, well, okay, he's just not going to come to school with a backpack or water anymore. And she would say that because she would know that it's the school rules that he needs to have those two items. And it's her way to sort of teach them a lesson, to settle that score, to sort of, she wants to get them to understand, if you mess with me, I'm going to make things worse. So let me do whatever I want to do. Anyway, that's what her reaction, that is believable that she's stating that. He got in trouble for something, so now no backpack and no water bottle because you guys called me out. And so now you can't call me out about this. And in reality, what's going to happen is, well, ma'am, we're going to have to call you out about not giving him the water bottle and the backpack because he needs it for other reasons. A normal parent would say, okay, this child needs to be disciplined. They need to have, talk to them, sit down, because I can't just deprive them of their backpack and water bottle. They need that for school. So we need to figure out how you can have your backpack and water bottle without you doing something inappropriate with it. That's what a normal, healthy parent would do. That's not what she would do. By the way, that's not what she would do because it would end the conflict. The action that she decided to take, which is to violate the school rules, continues the conflict. Anyway, I state that I have done everything in my power to communicate the issues with my ex, yet I failed to notify my ex when I had to call an ambulance for him. What? That's not true because she was notified. So guys, that's a Lego incident. He basically swallowed a Lego, and I did call the ambulance, and I did call her. What is she? So that's a lie too, and that's weird that she would do that because that's provable. I mean, I would think that I would have, unless I called her. So maybe it wasn't provable because I didn't email her, because I'm 99% sure I called her immediately, and all I can do there is show a record of a call. I can't show what was actually stated during the call. So that might have been why she decided to lie here, because she had an out. So the only thing I could do here is tell the court the opposite and show a phone record, which would just show a date and time as to when I called her. I gave her a letter from the school that was addressed to her at my address. She's unaware if there were other letters that she's not received. I doubt it. Before school started, we were to schedule an appointment to meet for his before school starts meeting testing. She was contacted by me and apparently the teacher, who had called to set up an appointment. At the last minute, the meeting was changed to a different day. She had to make arrangements to be there. That's pretty much what she does to me all the time. What she did to me all the time. The teacher refused to call my ex and work with her to set up a time. I don't know what so maybe she's trying to explain why she didn't go to a meeting. That's what that might be. The teacher would only contact me, once again leaving my ex to hear secondhand through me when and where the meeting was scheduled. So it was scheduled for 9 a.m. She showed up about 10 minutes early for the meeting and found that I and our son were sitting there. When my ex came in, the teacher stated that they were almost done. What? 10 minutes? What? The meeting takes 20 to 30 minutes, and my ex was 10 minutes early, so the meeting was not almost done. My ex asked if she was late, and the teacher said no, but she just had a student get done early, so they started. Okay, I don't know, I can't remember this incident, so I don't know if this is true or not. My ex missed the entire meeting except for the last 5 minutes. The teacher effectively kept my ex out of the meeting, preventing her from participating. My ex told the teacher that she didn't appreciate us starting without her and keeping her from participating. The teacher said sorry in a rude tone and said, I'm sure. This is the most my ex has spoken to her all semester. This isn't true. My ex was constantly berating them. And not only was she constantly berating them up until this point, she continued to do this all all the way until the end. It was to the point where she was trying to get people fired. And I have some suspicions to this day that maybe some of them did get fired, because there were a couple that disappeared after they had prepared affidavits for me. One of them was the attendance keeper, and I can't remember who the second one was, but maybe when we get to that point in my docket series, we can talk about that. But she's very, very obnoxious to them. It's like she was trying to get them to kick her out of the school, and through extension, kick our son out of the school. Let's see here. My ex is very interested in his education. She's volunteered every Monday when he was first enrolled, until he was kicked out of school, which he wasn't kicked out of school. I love that she's using that phrase, because this is what's frustrating, guys. So at the meeting with the dean and the teacher, they stated at least 3 times, and they even spoke to her very slowly, which makes me think that they had talked to her about this 1 or 2 weeks prior, because she went in, it was almost like she was reading from a script. She was like, okay, well, since now he's being kicked out of school, or okay, well, since this, and they would have to stop her and say, Ms. Farrar, he's not being kicked out of school. Ms. Farrar, he's not. After like 3 times, she finally said okay, and then she goes and files this opposition and says he was kicked out of school. So it's that sort of obnoxious slash like amnesiac sort of thinking. Like her brain would just reject statements that did not fit into her, I guess you could say, story or her characterization, more like her conclusion. The conclusion was, our son is a bad boy, he needs to be kicked out of the school. Anything that was sort of absorbed by her that was not consistent with that plan, she would just reject, or she would just forget that it happened. Or this could potentially be a bald-faced lie. I can't actually say that I think it's even most likely that. I'm not sure. And that goes to an incident from the very, very end of our high conflict child custody dispute, where she said something about her memory being unreliable. And at first I kind of laughed that off as ludicrous, but then I saw some videos from Sam Vaknin where he stated that this actually can happen. Now, she's not diagnosed NPD, but if she was, this is a thing, and he called it confabulation. And I really wish I could remember in detail what Sam Vaknin was talking about, but he basically said that people with this type of mental health issue have problems with confabulation of events, where they can't string together 2 memories if doing so would portray them in a light that would be humiliating or embarrassing. So their brain kind of just invents something, it creates a memory that doesn't exist, that never occurred, to sort of make everything fit together. That's the best I can explain it. So it is possible that she does legitimately forget these things. And there was another time when she did something even more ludicrous that really makes me think that it's totally possible that this is a problem that she had. And I'm gonna wait until we get to that point in my docket series, and hopefully I remember to bring this sort of this phrase up again, confabulation. Let's move on to the next paragraph. On October 4th, 2012, I emailed my ex's attorney notifying her that I was going to file a motion. My ex's attorney emailed back that day asking for what I intended to file. I responded that I had filed a notice of intent, and that I was thinking of attempting to get primary physical custody. My ex's attorney stated that she was open to any proposal so that further motion practice could be avoided. A week later, without any notice to my ex's attorney, I filed the instant motion in this case. So this is something that is really inane, and in fact, any attorney that looks at this would think it was ridiculous. When parties cannot agree, motions are filed. You do not have this magical, additional, extra special right that I have to run things by you before I can file them. That does not exist anywhere in the rules of civil procedure. And in fact, the closest thing you can get to that is a local rule in District 8, which states that parties have a requirement to confer and try to work things out. That's the closest that you can get. But that doesn't necessarily involve attorneys. It just says that the parties have to discuss things and work them out. Anyway, working something out doesn't mean I have to get your blessing to file something. The email that I sent prior was good enough. And what I stated in that email was, my ex is doing this, and this. And a week later, it hadn't stopped. So here we are. But she gets this sort of attitude, and I don't think it's a sincere attitude. I don't think it sort of organically popped up. What I think happened here is that the attorney wants to create a situation where she can portray me as a vexatious litigant. And so she needs to make these statements so that she can dupe the judge into thinking that I'm a vexatious litigant. So it's not that she's trying to speak authentically to the court to explain this is a sincere problem that we have. It's that she, just like my ex in some ways, needs certain conclusions to be true. And so she needs to make these statements to reach a specific conclusion so that she can get a specific remedy. I talk about why attorneys do this in the video, win at all costs. It has nothing to do with right and wrong and best interest of the child. It's just that they need to win, and since they need to win, they need to say certain things even if they're not entirely true, even if they have to bend the truth, even if they have to sort of strategically word their whatever it is that they're saying to get themselves to where they need to go. And in this case, I know she's going to accuse me of being a vexatious litigant and it's going to get shot down, but she's also repeatedly trying to get attorney fees from me, and it's a little bit more of a rocky road. Mostly goes in my favor, but there are a couple of situations where some stumbling blocks come up. Anyway, argument. She is asserting that my allegations do not rise to the level of modification. In Nevada, when a court determines the custody of a minor child, sole consideration is best interests, and then she cites the statute. A modification of custody is warranted only when there's been a substantial change of circumstances and the best interests are served. Ellis v. Carucci, that's a good citation. But this actually does, my understanding is that this does not apply in joint physical custody situations. Oh man. I just realized something. I didn't find this out until 2016, which means that this attorney, hopefully she legitimately did not know how the law worked. Hopefully she was not deliberately lying to the court. She's been wrong then from when this case started in 2008 to 2014, which is a total of 6 years. For 6 years, this attorney continued to tell the court that this legal standard applied, and it didn't. This legal standard does not apply. There are two different legal standards. One of them applies in joint physical custody situations, and the other one applies in all other situations. And the Ellis v. Carucci standard, which requires those two prongs to be satisfied, the change in circumstances prong and the best interest prong, does not apply in our situation because we have joint physical custody. The reason I just kind of had that stunned look is because I just recalled that this defense that my ex's attorney raised is a defense that she raised over and over and over and over again, and the judge bought it hook, line, and sinker the whole time. In fact, when we get to the point where I actually get the correct legal standard to apply in 2014, the first judge is already off the case. He's recused himself, and a second judge has taken over. Wow. It's frustrating because I think even if I was aware of the law, I think he would have still not believed me anyway, because I would have been a non-attorney and she would have been an attorney. And so she would have been able to continue to dupe him into applying the wrong legal standard. Anyway, let's continue on. The basis of my motion by my own admission is premised upon getting primary physical custody based on the teacher's allegations. I have failed to state any basis of substantial change of circumstances. So this is, at best, this is disingenuous. At worst, a bald-faced lie. So this is a change of circumstances. It absolutely is. If a parent is deliberately trying to sabotage their child's education, that counts as educational neglect. That is something that is occurring now that wasn't occurring then. So that does constitute a change of circumstance. I don't know why she would be so bold as to say that doesn't count as a substantial change of circumstances affecting our child's welfare. That's absolutely nuts for her to state that. It's one thing for her to state that it's not true. And it's another thing for her to state that the allegations that the teacher is making aren't true. But she's stating that the teacher's allegations don't meet that burden. If you guys read through that declaration, those allegations, if true, are huge. Because she's not just saying that my ex doesn't care. She's saying that my ex does care and that she is purposefully sabotaging our son's education. How an attorney can say that those allegations don't meet the burden is beyond me. A more reasonable attorney would say those allegations, if true, are concerning, but they aren't true. they don't, they if true, they warrant a modification, but we're going to go to court and show the judge that those allegations are not true. That is a much more reasonable approach. Okay, so we got here, rather than try to work things out with my ex through joint parent-teacher conferences or working through my ex's attorney, that's not working through my ex's attorney. That's giving my ex's attorney the power to act as a judge, which is another inappropriate statement. What's nuts to me is that if other attorneys were to read this document, I don't think that they would think that this is normal. I've gone out there a few times and I've stated that there are problems with attorneys in family law, but I feel like this one is making statements that go beyond reason. Anyway, let's see here. When I arrived early to the meeting, and I could have insisted the teacher wait. I could have encouraged the teacher to communicate directly with both of us. What? Instead, I filed an instant motion in this case a week after communicating with my ex's attorney. It shows that I would rather file motions with the court than work and resolve issues. Okay, so yeah, she's trying to, this is leading into a request for attorney fees. I can already tell. She's going to basically say, Your Honor, don't read anything that Alex has filed. Just count the number of filings. So he's filed 10 documents. Don't read any of them. Don't read those documents because they might actually have merit. Let's just use the fact that he's filed 10, just the number by itself, and let's say he's vexatious. Let me get some fees on that. And you know what? That actually works with a lot of judges. And that's because a lot of judges used to be attorneys, and they've gone up against non-represented parties, and a lot of times the non-represented party is unreasonable. And so what they do is they sell this lie to the court because it's a very believable lie. It's something that occurs all the time. And when you tell the court a lie on an issue that occurs all the time, what's the court going to do? They're not going to check into it. They're just going to assume you're telling the truth because it's something very common. When you try and lie to the court with something outlandish, like she did with the medical benefits cards, that is going to make the court say, hold on a second, prove it. But when you try to say something, hey, Your Honor, this person is doing something that 2,000 other people did last year. The judge is going to say, well, 2,000 other people did that last year. Yeah, he's probably doing that too. I don't need to really check up on anything. And that's a very common tactic by savvy attorneys. They find the lie or the deception that is the most believable, and they put that into the documents because they know the court's not going to bother to check into it because it's so believable just on its face. Oh, there's a request. Next statement. Bam. Attorney fee request. Pursuant to the law, the court enjoys the discretion to award attorney fees and costs associated with post-divorce actions. Leaming v. Leaming. That doesn't apply to this case because this is not a divorce. The court can make an allowance of attorney fees to a prevailing party. So we got NRS 010, subsection 2B does apply. 020 does not apply. 050 does not apply. 110 does not apply. So of those 4 statutes, only one of those statutes applies. In addition to these factors, the Nevada Supreme Court recently indicated that family law matters. The court has to evaluate a request for attorney fees upon the factors articulated. Okay, so the Brunzell factors are only applicable to determine the amount of the award. The Brunzell factors do not determine whether or not you are entitled to award. So you have to be entitled to an award before you can get to the Brunzell factors. Wright v. Osborne discusses child support. I don't know why she's bringing that up. Maybe there's something in there about attorney fees, but I doubt it. In the instant case, I filed a motion without providing any opportunity for us to confer. That's not a requirement under the law. The issues, unless you're in District 8, the issue could have been resolved through stipulation, saving my ex from... Okay, so this is an inane statement. An issue that could have been resolved through a stipulation prior to a motion can still be resolved through a stipulation after a motion. So she could have still tried to work it out. She could have still filed a stipulation. There's nothing that prevents her from filing a stipulation just because a motion is pending, and she knows that. So on purpose, she didn't respond to me in any way, shape, or form, and then she filed her opposition. So why didn't she talk to me before? Let's see. That wouldn't lead to the conclusion that she needs to get to. The conclusion that she needs to get to is that I am a vexatious litigant and I need to be sanctioned. If she works something out with me and we file a stipulation prior to the motion, that doesn't actually get her to where she needs to go. So that's why she didn't try. This has happened before on a number of occasions, at least 2 times. I have filed a motion and then we resolved it through a stipulation after the fact. It's completely possible and it's just something she didn't feel like doing. Conclusion, she respectfully requests that my motion be denied because that is not at all true. As previously noted, and I talk about this in another video where I discuss the Rooney case. I wish I could remember now. I think it's called adequate cause for a hearing, or maybe it's just lumped into the video on motions. Check that video out instead. My ex has always tried to cooperate with me when possible. It's not true. It's unjust to require her to oppose the motion and bear the burden of attorney fees and costs associated with the opposition. That's also not true. It's perfectly just for you to have to oppose a motion that is meritorious. If somebody files a motion with cause, it is totally just for you to have to file an opposition. If somebody just cooks up a bunch of lies, that's a different situation. But not taking him to school a bunch of times, not giving him a backpack, not giving him the water bottle, clothing that doesn't fit, trying to sabotage his education, all those allegations, if true, warrant relief. The court should deny my motion. The court should deny the request for whatever order regarding education. I'm not sure what that's about. And the court should order me to pay attorney fees and costs. Declaration in support. This is just a standard verification filed or included into the motion or opposition in this case by my ex, and that just states under penalty of perjury that the foregoing is true. So she's just making all of these statements under oath. That's what this specific piece here does. Here we have the affirmation, which is going to let the clerks of the court know that this document does not contain a social security number. Certificate of mailing under Rule 5 indicates that this document was mailed to me. Motion opposition notice, just like my motion opposition notice, hers is going to indicate that she needs to pay a $25 filing fee, so that's going to be some costs that she incurs on this filing. Index of exhibits. Here we have, looks like 4 exhibits, and exhibits 2, 3, and 4 are papers that were filed in this case. We're not going to go over those, as my standard policy in the My Docket series is. We don't go over duplicate documents. You can go down into the description below, click on the document, and review it for yourself if you'd like to. Post any questions down in the comments below. But we've already gone over those 3 documents in the My Docket series, so if you've been watching the series in order, you would have already seen my analysis on those documents anyway. This first exhibit, though, that's new, so let's take a look. Exhibit 1. Mission statement. Okay. School beliefs. Okay, so this is just her trying to state that this school is a pushy school. It pressures students into working hard, and that our son is not capable of handling that kind of pressure. She's just trying to use. She already talked about this at the hearing anyway. Going into the aftermath, I didn't file any documents, so I incurred $0 in costs. My ex's attorney filed 1 document with a filing fee, so she incurred $25 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. This is a pretty lengthy document. I think that it would have probably taken between 3 and 4 hours for my ex's attorney to put it together. I'm going to ballpark it at 3 hours and 15 minutes to put together the opposition. Then there would have had to have been some substantial communication with my ex. It's a substantial opposition. There are a lot of details in it. There is a few exhibits attached. Most of them are just on the docket, but there is that one exhibit. I think playing it safe, probably 45 minutes of discussion at least with between my ex attorney and my ex, and I think it's pretty reasonable, even on the conservative end, to say that 4 hours in attorney fees would have gone into this opposition at the rate of $250 an hour. That is going to come to $1,000 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.